The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to this session of the Kansas Supreme Court. It is a very special day. I am Marla Lugar, Chief Justice of the Supreme Court. Today we convene to conduct a special ceremony as we welcome Melissa Standridge to our court. Following the ceremony, we will call the first case set for oral argument on this court's docket. Today is not only a special day for the court and Judge Standridge, her husband Richard, and their family, but for all Kansans. As Judge Standridge moves from a judge of the Court of Appeals to serving as a justice on our court. It is a special and historic day for the administration of justice in Kansas. Today marks the culmination of a judicial selection process through which soon-to-be Justice Standridge was nominated and appointed to fill the position vacated by the retirement of Justice Carol Beyer. I want to thank the members of the nominating commission who spent countless hours reading, investigating, and interviewing applicants to nominate 3 potential and outstanding members of a panel to the governor. That panel was historic because for the first time, all 3 nominees were women. And I thank the governor and her staff for their careful consideration of those nominees. Those that of course resulted in the appointment of soon-to-be Justice Standridge. We have received from the Secretary of State, Scott Schwab, the official certificate of appointment. It reads, I, Laura Kelly of the state of Kansas, hereby appoint and commission Melissa Taylor Standridge as Justice of the Kansas Supreme Court and are authorized this appointee to discharge the duties of this office upon fulfilling all legal requirements. Before we get to that legal requirement of administering the oath of office, I would like to introduce Judge Standridge's friend and colleague, the Honorable Karen Arnoldberger, Chief Justice, a promotion herself, Chief Judge of the Kansas Court of Appeals. Judge Arnoldberger will present Justice Standridge to the court. Chief Judge Arnoldberger.
Thank you, Chief Justice Lukert. May it please the court, Judge Standridge, family members, and others who are watching today. It is a great honor for me to present to you my colleague and friend, Judge Melissa Taylor Standridge, for her investiture today. Judge Standridge will be only the 79th Kansas lawyer taking this oath since statehood in January 1861. Only 78 others have been called to accept this responsibility in the last 160 years. And she will be only the 6th woman in Kansas history to hold the office. That accomplishment is even more amazing when you realize that this year is the 100th anniversary of women having their inherent right to vote as citizens of this country recognized by the 19th Amendment to the United States Constitution. I'd like to take a few minutes to tell you a little bit about your new colleague. She is the great-granddaughter of Jewish immigrants from Russia on both sides of her family. They left Russia fleeing persecution and seeking a better and more secure life for their families. Upon arriving in the United States with nothing in the late 1800s, they eventually settled primarily in the Chicago area. They were tailors and grocery store merchants, rabbis and builders. They worked hard and were able to buy their own businesses and serve as shining examples of the American dream. They instilled in their children and grandchildren an appreciation for hard work, the importance of an education and scholarship, and a deep-seated belief, primarily based on their own experiences, in justice. She never knew her maternal grandfather, a renowned doctor in Chicago who developed cutting-edge procedures to save newborn babies, because he was tragically killed while serving his country as an army doctor in 1942. So her story is the American story, and she comes to her role with those shared values and life experiences. And Judge Standridge, a lifelong Kansas resident, has lived those values. As a single lawyer, she felt a calling to become a foster parent, which resulted in her adopting 3 of her foster children when they were just toddlers. She has navigated the foster care system in both Kansas and Missouri and brings that experience with her to the bench. Upon marrying now retired Judge Richard Standridge, he adopted the children, and when the mother of one of her children had another child, they adopted the baby together. That baby, Quentin, now a 6th grader and the only child still remaining at home, I have to tell you one personal thing, is obsessed with things mechanical. When my husband gave him our own lawnmower to tinker with, you would have thought he gave him $1 million. He updates us regularly on what our lawnmower has now become, with its dirty old parts turned into shiny parts for the new motor this 6th grader is building. But I digress. Suffice it to say, she has amazing children. One last thing I want to warn you about your new colleague. She has a heart as big as this state and a commitment in her personal life to help those among us who lack power and influence. Jonathan Harnish famously said, "The strongest people are not those who show strength in front of the world, but those who fight and win battles that others do not know anything about." Judge Standridge is a battle-tested warrior. You can easily read about her stellar scholastic record, her amazing judicial career on the Court of Appeals, and the awards she has received. But she is so much more than those outward manifestations. She has not just talked the talk about the importance of diversity in the legal profession and on the bench. She has walked the walk by mentoring young high school and college students. She's helped countless people of little means and influence navigate complicated legal systems. She believes strongly in procedural fairness, and she cares deeply about the impact of her decisions, both now and in the future. She's a strong advocate of the rule of law and adheres to it with a laser focus. I speak on behalf of my colleagues in saying that we will miss Judge Standridge on the Court of Appeals. Her intellect, her wit, her collegiality, and that distinctive laugh that you can hear anywhere on the 2nd floor when it erupts. But thanks to the sound judgment of Governor Kelly and the nominating commission, the state of Kansas will gain a jurist that has all the qualities we seek in a judicial candidate. Neither the governor nor the state of Kansas will be disappointed. We on the Court of Appeals know what kind of justice she will be because we have seen what an amazing judge she is. May it please the court, it is my distinct pleasure to introduce Judge Melissa Taylor Standridge for swearing in as Justice of the Kansas Supreme Court.
Thank you, Chief Judge Arnold Berger. Okay, so now we do get to the part of the ceremony that makes the governor's appointment effective, the taking of the oath of office. Judge Standridge, if you would please raise your right hand as I administer your oath, and then please swear or affirm that you accept it. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Kansas, and will faithfully discharge the duties of the Office of Justice of the Kansas Supreme Court. So help me God.
I do.
Applause again. Everybody unmute and applaud with me. At this time, I formally call you Justice Standridge. Congratulations and welcome to our court. Judge Standridge, and I am now referring to Judge Richard Standridge, would you please assist the justice in donning her judicial robe?
I will.
First time as Justice of the Kansas Supreme Court. Congratulations once again. We welcome you to our virtual bench, and please I'm sure you have remarks you would like to make, and we are anxious to hear them.
Okay, trying to. To Chief Justice Lukert, my fellow judges and lawyers, friends and family, thank you for virtually joining me today as I take the oath of office. And a special thank you to Chief Judge Karen Arnoldberger for her eloquent and meaningful introduction of me to the court. Karen, you are an extraordinary colleague and an exceptional friend. I also want to thank Governor Kelly for my appointment. The other two nominees, Judge Kim Cudney of Washington and Kristen Wheeler of Wichita, both are exceedingly well qualified for this position. I'm humbled and honored that the governor chose to place her confidence in me. I'm deeply grateful, as the Chief Justice mentioned, to the members of the Supreme Court Nominating Commission. The role that the commission plays in the merit selection process is absolutely critical to maintaining an independent, fair, and competent judiciary. And I would be remiss if I didn't thank all my colleagues on the Court of Appeals with whom I've worked over the course of the last 12 plus years. It was both an honor and a pleasure to work with such a smart, hardworking, and collegial group of judges. And to Trish Heim, my judicial executive assistant and paralegal for the past 12 years. I would not be here today without your extraordinary administrative and personal support. Of course, there are 6 very significant supporters that I must acknowledge and thank by name. My children, Duncan and his wife, Caitlin, Claire, Sergio, Clint, Anna, and Quentin. You are the light of my life, and each one of you makes me so proud. And my final and most important note of thanks goes to my husband, retired Judge Richard Taylor Standridge. Richard, you are an extraordinary husband and partner, and my best friend in the whole world. Having taken the oath, I'm eager to get started. As the newest member of the Kansas Supreme Court, I intend to diligently perform the duties of the office and do my best to promote public trust and confidence in our system of justice. Thank you for this opportunity.
I wish we were together so that we could share a warm handshake and a embrace. But please feel it coming to you over the airwaves, or however we say this with the Zoom world, because it is genuine and wholehearted as we welcome you to the Kansas Supreme Court. I thank you all for joining us for this ceremonial portion of today's session. I would ask Sarah Stratton, the appellate reporter of decisions, to make today's ceremony a part of the permanent record of this court by publishing them in our official reports. I thank all of you who have joined us online for sharing in this ceremony. I invite all of you to stay online as we call this morning's first case. There will be a momentary delay as we bring the attorneys in that are arguing this appeal, but trust me, true to Justice Standridge's words, we're only giving her a few moments of pause as we put her to work. So thank you.
Hope, can we get just a quick sound check again?
May it please the court? Testing.
Thank you. Daniel, can I get a quick sound check one more time?
May it please the court, state appears by Daniel Obermeyer.
Perfect. Chief, I think we're ready to go once all the justices are back in place.
All right, thank you, Mr. Shima. I would now ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Monday, December 14th, 2020 consists of one case. Appeal number 121685, State of Kansas versus Carlos Antonio Gallegos, Wyandotte County, briefs both sides. Your Honor, the appellant has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Madam Chief Justice, and may it please the court, the state of Kansas appears by Assistant District Attorney, Wyandotte County, Daniel Obermeyer.
Madam Chief Justice, and may it please the court, Mr. Carlos Gallegos, the appellant, appears by Hope E. Faflick Reynolds, Assistant Appellate Defender.
Thank you, counsel. As you know, the court has read your briefs and we are anxiously awaiting your arguments. Ms. Faflick Reynolds, you may proceed.
Thank you. May it please the court. By way of background, this appeal follows Mr. Gallegos' conviction at a jury trial for first-degree premeditated murder in the death of Monica Shavira. Because Mr. Gallegos confessed to police and testified on the stand that he committed the killing, the true issue is how Kansas criminal law should classify that killing. Today, I plan to focus on the first issue in Mr. Gallegos' appeal, the lesser included instruction of voluntary manslaughter. Although Mr. Gallegos requested the instruction of the lesser included offense of voluntary manslaughter, the district court found that that instruction was not factually appropriate. When reviewing the district court's decision, this court should view the evidence light most favorable to Mr. Gallegos. Mr. Gallegos testified that in the killing, "I just did it, you can't think." He also said that he couldn't describe or recount parts of the killing, saying he could only say he was out of control. These statements Mr. Gallegos made during trial are consistent with his account that he gave police shortly following the killing. Because the evidence supported an instruction on voluntary manslaughter, which Kansas law defines as an intentional killing with legally sufficient provocation, the district court erred in refusing to give the instruction to the jury. This failure is especially harmful to Mr. Gallegos because the sole issue at trial is the type of murder the killing should be classified as. His confession and testimony make the inability of the jury to consider each type of offense especially harmful in his case.
Counsel, what is the record evidence supporting adequate provocation here?
The record shows in Mr. Gallegos' testimony that immediately preceding the killing that he and Ms. Shavira were in an argument, that she began screaming, and that he reacted to the screaming impulsively.
So it's the screaming part that is that your position, that the screaming is the factual basis for adequate provocation?
The screaming and the argument that preceded the killing, yes, Your Honor. And the argument follows or arose because of a robbery that Mr. Gallegos was the victim of a couple of days beforehand, that was committed by Ms. Shavira's romantic partner or boyfriend, Mr. Jones. In that robbery, Mr. Jones held Mr. Gallegos at gunpoint and took money from him. Now that was a couple of days prior to the killing. And so we are not asserting that that is the provocation, but rather the argument between Ms. Shavira and Mr. Gallegos in the hotel room immediately before the killing.
But what do we know about that argument? I guess that's what I'm trying to understand. Besides the screaming in response to his aggression towards the victim, what do we know from the evidence about the nature of this argument?
The evidence at trial shows that her screaming was not because of aggression toward the victim, but rather was part of an argument between Ms. Shavira and Mr. Gallegos. Mr. Gallegos had made an appointment with Ms. Shavira, planning to use her to lure Mr. Jones to the hotel room to exact revenge or payback upon him for this robbery that occurred a couple of days beforehand. When that plan unraveled, because Ms. Shavira refused to call Mr. Jones, Mr. Gallegos testified that he told her, "My problem is with you now," became upset, got mad, and impulsively strangled her. So that is what the record shows about the evidence. And that testimony is in volume 11 in pages 340 to about 360, Your Honor.
We use the word impulsively, but by his own statements, he recounts the actions he took between that moment really and beginning the act of strangulation. He pulled his shoestrings out of his shoes. He wrapped them together. There are contemplative actions actually leading up to the act. How does that square with the request for the lesser included offense instruction?
I think that a reasonable inference from using a shoelace to strangle a person is that that is a contemplative action. I also think that a reasonable inference from using a shoelace as a weapon is that he didn't have other weapons. So he had to resort to using a shoelace. He did not bring a gun to the hotel room. He did not bring a knife or another weapon better suited to harming people. Instead, he impulsively made a decision to use he impulsively used what he had, which was a shoelace. It's also in the record that this occurred after Ms. Shavira and Mr. Gallegos had been sexually intimate, and the argument started while he was undressed following their encounter. So I think that when you're getting dressed and tying your shoes, a shoelace is more readily available, which is why it could be a reasonable inference that a jury should decide whether that was an impulsive act or whether it was a premeditated act. The evidence also says that Mr. Gallegos did this act in a state of anger, and that he did it without thinking, and that he was out of control. So when viewed in the light most favorable to Mr. Gallegos, as the standard of review requires, a reasonable inference that a jury could make is that this was an act without reflection and done impulsively, like this court defines voluntary manslaughter in the first place.
Are there other questions?
I know you were focusing on issue 1, but in terms of the voluntary intoxication instruction, was there any evidence of, there was evidence of consumption, but what evidence exists of impairment?
The evidence that exists of impairment because of intoxication is his testimony on page 347 of the record that says he was out of control when he committed this violence. There is not evidence about the degree of intoxication, only that he was out of control and acted without thinking, which a jury could infer is the result of intoxication. Also, because Mr. Gallegos did not have an opportunity to argue intoxication to the jury wasn't able to decide whether or not that defense should apply to his convictions. This case really comes down to how we want district court judges to act as gatekeepers in the instructions that we give to juries. Mr. Gallegos asserts that we should trust juries with the relevant instructions when a defendant presents evidence supporting those instructions, and allow juries to make decisions about the proper convictions and which offenses apply. If there are no more questions, I will yield the rest of my time.
Any questions? Okay, thank you. Mr. Obermeyer?
Thank you, Madam Chief Justice. I'd like to review, for anyone watching this who may have questions about the facts of this case, go more into the trial testimony, and then discuss why voluntary manslaughter was not a factually or legal, or it was a legally appropriate case. This state acknowledges that, but not factually appropriate in this circumstance because there was no legally sufficient provocation for it, that instruction to be given. And then move into issue 2, the voluntary intoxication instruction. And thirdly, I'll touch on the issue of prosecutorial error in this case. The evidence in this case showed that on July 5th, 2016, Monica Shavira, who had put herself on a website called Backpage.com, trial testimony in that was that it is a dating website, but is also used for prostitution purposes. She had a profile on that page giving her information. The defendant admitted to contacting her using a website, and he set up, as he said in his testimony, a sexual appointment with her. There was also trial testimony that the defendant knew Monica had previous encounters with her some days before, about 3 or 4 times. Monica Shavira at that point was basically living sort of a transient life, is the way I would describe it, with her boyfriend, Andre Jones, and a Miss Lakiva Rowe. At that point, they were, on July 5th, they were living out of a hotel room off of Southwest Boulevard in Kansas City, Kansas. Mr. Jones and Miss Rowe removed themselves from the hotel room while Ms. Shavira had her rendezvous with the defendant in this case. And the state's evidence in this case was, in addition to the defendant's confession, was overwhelming. The defendant was seen going into Monica Shavira's hotel room, and he was seen walking out, and no one came in or out of that room until Miss Rowe came into that room, where she found Monica Shavira dead. The testimony in this case was rather graphic, even as far as strangulation cases go. The coroner in this case testified to the severe damage done by the ligature marks in Ms. Shavira's neck. There was also evidence that she had scratched herself trying to get the shoelaces, which were the admitted murder weapon in this case, off of her neck. He testified that the pathologist testified that it would take 2 to 5 minutes to complete strangulation of this kind. And even the defendant himself estimated that it took him about 50 seconds. So we're talking about a significant period of time, whether we're going with the testimony of the forensic pathologist or of the defendant himself. There was testimony, the defendant took the stand in this case in his own defense, and his testimony in this case was that Ms. Shavira had basically set him up to be robbed by Mr. Jones some days previous. In his statement to police, which is State's Exhibit 11 and 11A, he told police that he had been robbed of $100. He wouldn't give the amount on the stand, and that's just one part of his very, one might say, erratic testimony at trial. But he did, in his statement to police, admit to wanting to get revenge on Mr. Jones, and I believe also Ms. Shavira, because he believed that she had set him up for this robbery. And he, in his statement to police, said that he was going to kill Mr. Jones. He wanted to kill him. And his trial testimony, that changed to he wanted to break Mr. Jones's hands to teach him a lesson so that he could only ask for things in words. So in his testimony at trial, when he was asked if he was angry over this incident, he described himself as angry as a poked tiger. Also in his statement to police, when police got to the point where they were asking, so he said that he and Monica had sexual relations, and that after he was done, he asked her to call in Mr. Jones, and she refused. She wouldn't cooperate. I think at that point she knew that something bad was going to happen to Mr. Jones if she accessed to his demand. So in his statement to police, the defendant said, "I shut her up." And how did you make her shut up? Well, I killed her. And and then says, you do it. It's unintelligible there. And then he says, I was really mad. And he admits to doing it with her shoelaces. He confirms that he killed her. And then also in his statement later, he says, I did it for revenge. I know that before the law here, revenge doesn't exist, but I made a decision. I know that I'm going to hell, you know? And you can find those quotations on State's Exhibit 11A, pages 35 through 36 in his statement. And as I said earlier, his trial testimony substantially tracked with this part of the statement that he gave to police. Touching on the issue of voluntary manslaughter, two things are required for voluntary manslaughter. There must be an intentional killing with legally sufficient provocation. Here, there was no legally sufficient provocation. Legally sufficient provocation is something that would cause an objectively reasonable man to act out of passion rather than reason. And the district court in this case gave a very thorough, very thought out reason for why it was not going to instruct on voluntary manslaughter. It noted the number of things that the defendant could have done but did not do in this case. He didn't beat Ms. Shavira with his hands. He didn't beat her with a lamp. Instead, when she starts yelling for help, he takes off his shoelace and then he strangles her. And this, the standard in this, it's not any evidence whatsoever. The jury instructions to be appropriate, there must be evidence which would reasonably justify a conviction on the lesser included offense. And here we just don't have evidence of legally sufficient provocation. This court has said that just mere evidence of a quarrel is not in of itself sufficient. It also has the district court in exercising its judicial gatekeeping functions has to take into account the circumstances of the quarrel, the reasons why it occurred. And it just can't say we had an argument and therefore I killed the victim. That is not legally sufficient provocation. But that's essentially what happened in this case. He was upset because she started screaming and he had to shut her up, in his own words. Touching on the issue of the voluntary intoxication instruction, the testimony at trial was that he had 6 beers between noon and 5 o'clock. He doesn't say what type of beers. Any beer connoisseur knows there's a difference between a Natty Light and, say, a Boulevard Tank 7 in terms of alcohol content. So we don't even know what type of beer he was drinking. But regardless of that, as the district court noted, the defendant at all times is in control of his actions. He's able to use his phone. He's able to continue working. He's able to drive from work to the hotel room. He's able to engage in sexual relations with Ms. Shavira. He's able to continue with his plan for revenge, that is trying to get Mr. Jones to the hotel room so that he can either kill him or break his hands, depending on which version of events the defendant testified to. Additionally, so all of these things indicate that there is no impairment. And regarding counsel's reference to page 347, that he was out of control, that in of itself doesn't necessarily indicate that that was due to alcohol. That could be due to the defendant's temperament. That could be due to any number of things, and just acting without thinking. That's also, there's no evidence at all that that's connected with his alcohol consumption. So in this case, really what we have is mere consumption without any evidence that this impaired him. And I'd also note that he was able to give a fully cogent and reasonable defense and give details to the police and in his testimony about what happened that day. So that also cuts against the argument that he was so impaired to the degree that he could not form the requisite mental intent.
Counsel.
On the issue of the prosecutorial error in this case, I want to read the full quote that the defendant complains of.
Counsel?
Yes, Justice.
Can you infer, could a reasonable juror infer impairment based on the evidence of the amount of consumption over a specific period of time? In other words, a large quantity over a short period of time. Is it a reasonable inference to find impairment based on those underlying facts?
Not on these underlying facts, and that would really depend on the facts of the case. This court has held, I believe this court, it's been quite clear that we don't judge impairment just by mere consumption. And there have been cases where a defendant has admitted to drinking heavily and used methamphetamine or other drugs, and because they're still able to reason through things, to think through things, to provide a detailed account of events, that all indicates that they're not actually impaired to the degree that they cannot form the requisite intent. And the defendant's testimony in this case was that he performed many actions which require coordination and deliberation, up to and including actually killing Ms. Shavir. Does that answer Your Honor's question? All right, thank you. There's two comments that the defendant complains of in this case the prosecutor committed error on. The first is the period of her closing argument where she says, "Ladies and gentlemen, you may not agree with the way Monica Shavir was living her life. She was prostituting herself, there's no question about that. But no one, no human being deserves to die the way she died, struggling for breath, being conscious of what happened to her, trying to remove shoelaces from her neck so forcefully that she was gouging herself. And you've seen that from the pictures. Left to die in a motel room off of Southwest Boulevard. Nobody deserves to die like that, regardless of what they do." And again, the prosecutor later said in a rebuttal argument, "Monica Shavir's life was worth more than $100. It was worth more than his pride," meaning the defendant's. And as I just told you, the state does not have to prove that he woke up that morning intending to kill her. But all the evidence in this case, and most importantly, her body and the way that Dr. Mitchell, the forensic pathologist, could read her body with expertise, shows that this was done with premeditation. And in this context, the prosecutor is not arguing for sympathy for Ms. Shavira. What she's actually doing is she's showing that the defendant had motive to kill her. The defendant's own words were that Monica was prostituting herself. And that is a lifestyle that many people do not agree with. And so that also might cast Ms. Shavira in an unfavorable light before the jury, but that's not a relevant consideration as to whether or not the state has proven all the claims it needs to prove this case beyond a reasonable doubt. So really what she's doing is arguing to the jury not to let whatever prejudices they might have in the way that Monica Shavira was living her life impact their decision in this case. And there's a number of cases that the Court of Appeals has addressed that I cite pages 27 and 28 of my brief, where prosecutors have said similar things. And this court has, and the Court of Appeals at any rate, has held that these remarks were within the wide latitude which is granted to prosecutors in closing argument. And if this court does find error in any of these claims which the defendant presents, the overwhelming evidence of this case really shows that none of these would have made a difference. The defendant was given the lesser included instruction of intentional murder, and the jury found the additional element of premeditation in this case. And additionally, there's just circumstantial evidence, there's direct evidence to support the defendant's guilt. So in closing, I would ask this court to affirm the decision of the district court and find that no error was committed in denying the defendant instructions from voluntary intoxication and voluntary manslaughter, and to find that the prosecutor did not commit error in this case. Thank you.
Thank you, Mr. Obermeyer. Ms. Faflick-Reynolds, you reserve 3 minutes of rebuttal time.
May it please the court. I want to emphasize when opposing counsel said on page 347 of the record that Mr. Gallegos said he was out of control. Opposing counsel said that could be due to anything. And that is precisely Mr. Gallegos's argument, is that a jury should decide what that reaction was from. Was it from intoxication? Was it an impulsive reaction without thinking, like voluntary manslaughter? These are questions for a jury. We ask that this court reverse Mr. Gallegos's convictions and remand for a new trial where a jury is fully instructed on the lesser included offense of voluntary manslaughter, as well as the defense of voluntary intoxication. Thank you, Your Honors.
Thank you to both counsel for your arguments. The court will take this appeal under advisement, and we are now in recess until 11 a.m.